Let's kick off this explainer by asking a rather massive question. How exactly do vast international treaties and a century-old rulebook directly protect your daily life and right historical wrongs? It's kind of like a giant invisible puzzle, and today we're going to unpack the entire Australian legal ecosystem to see exactly how these huge global concepts filter all the way down to your individual rights.
To rack our heads around this, we've got a really clear path today. We'll start with Australia on the global stage, then look at the rulebook, the Australian Constitution. After that, we'll talk about changing the Constitution, overturning Terra Nullius in the famous Mabo case, and finally, how this whole cohesive legal ecosystem actually fits together.
All right, Section 1. Australia on the global stage, treaties, rights, and the UN.
So, when Australia takes its seat at the UN, they're really focusing on a few core ideas. It's about protecting human rights, those basic freedoms that just uphold everyday human dignity. It's about elevating living standards so people have the bare necessities to survive, responding to devastating humanitarian crises, and of course stamping out discrimination so nobody faces unfair treatment just for being who they are. These concepts are absolutely the bedrock of Australia's international obligations.
To actually put those big concepts into action, the UN adopted these 17 Sustainable Development Goals back in 2015. Australia made a direct pledge to hit these specific targets to end poverty, protect the planet, and improve well-being by the year 2030. So it basically provides a real actionable roadmap for global progress.
And this whole framework, it's backed by some seriously foundational documents, like the Universal Declaration of Human Rights from 1948, which guarantees rights to life, freedom, and safety. Plus, Australia makes major environmental commitments on the world stage too, like the 2016 Paris Agreement, where the nation committed to limiting global temperature rise to less than 2 degrees Celsius above pre-industrial levels.
Now you might be wondering, how does a country actually lock itself into these global standards? Well, they do it through treaties. You've got bilateral treaties, which are strictly between two state entities, and multilateral treaties, which involve two or more sovereign states sharing the same obligations. But here's the crucial part, and why this actually matters to you. Just signing a treaty doesn't automatically change Australian law. Nope. The federal parliament has to review those treaties and actually pass enabling legislation to weave those global rules into domestic, everyday law.
Moving right along to Section 2, the Rulebook, the Australian Constitution and Structuring a Nation.
At the very heart of this national rulebook, you've got four foundational pillars. First up, democracy. Citizens elect their representatives. Second, the separation of powers to ensure accountability. Third, the division of powers, meaning responsibilities are shared out between federal, state, and local governments. And fourth, the rule of law. This one is absolutely vital. It means every single citizen, right up to the highest government officials, is bound by the law. Nobody gets a free pass.
If we dive a little deeper into that separation of powers, we find this highly deliberate triangle designed specifically to prevent tyranny. You have the legislature making the law, the executive administering it, and the judiciary applying it. They act completely independently, but they also cooperate. This triangle basically balances authority so that no single group can grab too much control.
That brings us to Section 3, changing the Constitution. Section 128 and referendums.
Now, a rulebook written way back in 1901 simply can't anticipate everything, right? So when it absolutely needs an update, Section 128 creates this really rigorous pathway known as a referendum. First, a proposed change has to pass through both houses of parliament. Then it faces what's called a double majority test at the ballot box. This means it requires a majority of voters nationally to vote yes, and a majority of voters in a majority of states, so at least 4 out of the 6 states have to give it a thumbs up. This high bar embeds direct democratic legitimacy while making sure changes aren't just rushed through on a whim.
And hey, this mechanism is absolutely not just theoretical. The historic 1967 referendum showed the sheer power of this process. It allowed the Commonwealth to finally make laws for Indigenous Australians and include them in the national census. It reflected this profound, fundamental shift in national values toward equality and actual recognition.
Next up, Section 4, overturning Terra Nullius, Mabo and common law correcting history.
To truly understand the Mabo case, we've got to understand exactly what it overturned. For over 2 centuries, Australian law operated on the legal fiction of terra nullius, which literally translates to land belonging to no one. This was the devastating historical premise that at British settlement in 1788, the Crown just automatically acquired the entire continent, which completely erased any concept of indigenous land ownership under the law.
Eddie Mabo and the Meriam people fought an absolutely exhausting, decade-long legal battle to fix this historical wrong. Starting in 1982 in the High Court, they faced immense pushback. The Queensland Parliament even passed laws in 1985 to try and completely wipe out their claims. But remember those branches of power we talked about? In 1988, the High Court invalidated that Queensland law because it clashed with the Federal Racial Discrimination Act. Finally, in 1992, the High Court delivered its landmark decision, ruling that the whole concept of terra nullius was legally invalid. Then, boom, the High Court's 1992 decision completely reshaped the legal landscape forever. It formally recognized that Indigenous peoples possessed an organized system of land ownership long before 1788. By rejecting terra nullius, the court birthed the legal concept of native title, acknowledging that Indigenous land ownership could actually continue post-settlement, provided, of course, that a continuous connection to the land could be proven and it hadn't been lawfully extinguished.
But, the judiciary doesn't just operate in a vacuum. Following the High Court's decision, the federal parliament stepped right in and created the Native Title Act of 1993. This is literally the separation of powers playing out in real time. The judiciary made a groundbreaking common law ruling, and then the legislative branch followed up by creating comprehensive statute law to manage and codify native title across the whole country.
And finally, Section 5, the cohesive legal ecosystem. Let's see how it all connects.
So how do all these totally distinct parts, the UN, the Constitution, and massive High Court cases, actually form a single living ecosystem? Well, it all connects beautifully. International treaties set the global moral baseline. The Constitution builds the arena, dividing power up to prevent tyranny, and giving us a democratic update mechanism via referendums. While the Commonwealth handles the big national issues, states hold on to residual powers for day-to-day local matters. And if federal and state laws ever bump heads, Section 109 of the Constitution acts as this legal safety net, guaranteeing federal law wins out. Meanwhile, the independent judiciary sits ready to interpret these laws and protect fundamental rights, exactly as we saw in the Mabo decision.
It all works perfectly in tandem. Whether Australia is locking in global climate agreements over in Paris, or formally acknowledging traditional native title on the Murray Islands, the structural rulebook of the Constitution ensures that judicial innovation and legislative responses all happen within a completely protected and balanced framework.
Which leaves us with a pretty fascinating final thought. When you look at this vast, invisible web stretching all the way from the halls of the United Nations right down to the very land you're standing on in your local community, how does this immense legal machinery actively protect your basic rights today? And perhaps more importantly, how do you think it might evolve next to protect the rights of future generations? Think about that for a bit and keep exploring.